It is 9 o'clock at night. You are sitting in your living room, relaxing after a long day. Suddenly you hear it. A heavy, aggressive pounding on your front door. Then a voice, "Police, open up." In that split second, your heart rate spikes. Your instinct, your polite, law-abiding instinct, is to stand up, walk to the door, unlock the deadbolt, and open it to ask, "Officer, what is the problem?" If you do that, you have just made the single most dangerous legal mistake a gun owner can make. By turning that lock and cracking that door, you have surrendered legal protections that the Fourth Amendment took centuries to build. You have taken a situation where you had 100% of the power, and you have handed it over to the state. Today, I am going to give you the exact verbal script you need to handle a police knock at your door. I will teach you how to communicate without ever unlocking your deadbolt. We are going to cover the plain view doctrine that turns your open door into a trap. We will cover the 3 specific things you must verify if they claim to have a warrant. And I will explain why stepping out onto your own front porch can legally be considered the same as standing in the middle of a public street. This is not about being anti-police. This is about being pro-rights. Because once that door is open, you can't close it again. Let's start with the universal rule. This applies in all 50 states. It applies whether you are in California or Texas, New York or Florida. The threshold of your home is the legal equivalent of a castle wall. The Supreme Court has repeatedly held that the home is the most protected space in America. In the eyes of the law, a man's home truly is his castle. But that protection has a physical limit. It ends at your doorway. There is a legal concept called implied license. This means that in our society, there is an unwritten rule that any visitor, the mailman, a Girl Scout selling cookies, or a neighbor, has permission to walk up your driveway, step onto your porch, and knock on your door. Because the public has that license, the police have it too. They are allowed to walk up and knock. That is not considered a search. That is just a knock and talk. However, that license ends the moment you answer. You have absolutely no legal duty to open that door. None. Zero. You do not have to answer. You do not have to speak. You do not have to unlock the deadbolt. Most people believe that if the police are knocking, they must open the door to resolve the situation. That is false. Unless they have a warrant or there is a dire emergency, which we will discuss later, that door is a barrier they cannot cross. But the moment you open it, you break the seal. Why is opening the door so dangerous? It comes down to 3 words: the plain view doctrine. The Fourth Amendment says the government needs a warrant to search your home. But the courts have created an exception. If an officer is standing in a place where he is legally allowed to be, like your front porch, and he sees evidence of a crime with his own eyes, he does not need a warrant to seize it. Think about what is visible from your front door. Maybe you have a rifle case sitting in the hallway because you were cleaning it. Maybe there is a messy table in the background. Maybe a family member walks by. If you open the door to be polite, the officer is now looking directly into your sanctuary. If he sees something he deems suspicious or contraband, he now has probable cause. That probable cause can be used to get a warrant to search the rest of the house, or in some cases, it gives him the immediate authority to enter and seize the item. By opening the door, you have turned a consensual encounter into a potential investigation. You have voluntarily lowered your shield. That is why the first rule of this strategy is absolute. The door stays closed. So, the officer is pounding on the door. You are inside. You are not going to open it. But you can't just hide behind the sofa, especially if they are persistent. You need to take control of the interaction verbally. You are going to speak through the door. You can shout through the wood, talk through a closed window, or use a video doorbell system. But the barrier remains. Here is the script. I want you to memorize these 4 simple phrases. Phase 1 is identification. You ask, "Who is it?" They will announce themselves. Police department. Phase 2 is determining intent. You ask, "How can I help you?" Notice I didn't say, "What do you want?" or "Why are you here?" "How can I help you?" is polite but firm. It forces them to state their business. Usually, they will say something vague. "We just want to talk," or "We had a report of a disturbance," or "We need to ask you a few questions." This leads to phase 3. This is the most important line you will speak tonight. You say, "I am not coming out. We can talk through the door." If they ask you to open the door so they can hear you better, you repeat it. "I can hear you fine. I am not coming out." Now, often, this is where the pressure starts. They might say, "Sir, we just need to clear this up. Open the door or we're going to have a problem." Or they might demand to come in. That brings us to phase 4, the shield. You ask one question: "Do you have a warrant?" If the answer is no, or "We don't need one," or "We just want to check on you," then your response is final. "I do not consent to any searches." "Please leave my property." Then, you stop talking. You walk away from the door. You have asserted your rights. You have denied consent. You have not opened the threshold. You have won. Now, I mentioned earlier that there is a specific trap waiting for you if you try to be too helpful. This is the step outside trap. Sometimes, an officer will say, "Look, I can't shout through this door. Just step out onto the porch so we can talk man to man. I'm not going to enter your house." That sounds reasonable. It sounds like a compromise. You come out, the house stays closed. Everyone is happy, right? Wrong. There is a Supreme Court case called United States versus Santana. It established something critical about your doorway. The court ruled that when you are standing in your open doorway, you are in a public place for the purposes of the Fourth Amendment. If you step out onto the porch, you have left the sanctuary of your home. You are now in the public domain. If the officer decides he has probable cause to arrest you, maybe he claims he smells something, or he misinterprets your nervousness as aggression, he can arrest you right there without a warrant. Furthermore, if you are arrested outside, they can search your person incident to arrest. They can check your pockets. They can check your waistband. But it gets worse. If you are standing in the doorway and they initiate an arrest and you try to retreat back inside, they can follow you in. It's called hot pursuit. By stepping into the threshold, you gave them the opportunity to initiate an action that ends with them inside your living room. Do not step outside. Do not cross the threshold. Stay inside where the Constitution protects you. Now, you might be thinking, but what if they lie to me? What if they say they are checking on my safety? This is a common tactic. It is perfectly legal for the police to use deception to gain consent. They are allowed to lie to you. They can say, "Your neighbor said they heard a scream," even if the neighbor just complained about a barking dog. They can say, "We just want to check the perimeter." They use these lines to trigger your social instinct to be helpful. They want you to say, "Oh no, everything is fine. Come in and look, see? No screams here." Do not fall for it. If they truly believed someone was screaming or dying inside, they would not be knocking and asking for permission. They would be kicking the door down under the emergency aid doctrine. The fact that they are standing there asking you to open the door proves that they do not have enough evidence to come in legally. They need your permission to bridge that gap. Do not give it to them. Let's move to the other scenario. You ask, "Do you have a warrant?" And they say, "Yes, we have a warrant." Open up. Does this change the game? Yes. If they have a valid warrant, you cannot stop them. Refusing a lawful order to open the door for a warrant can lead to your door being destroyed and you being charged with obstruction. However, you still do not just blindly swing the door wide open. You have a right to verification. You say, "Please slide it under the door," or "Please hold it up to the window so I can see it." You need to verify 3 specific things on that piece of paper before you unlock your castle. First, check for a signature. A warrant is not valid unless it is signed by a judge or a magistrate. It needs that judicial authority. No signature, it's just a piece of paper. Second, check the address. This happens more often than you think. Police raid the wrong house. Look at the street number. Look at the street name. If you live at 104 Maple Street and the warrant says 106 Maple Street, do not open that door. Tell them, "This is the wrong address. You are at 104. That warrant is for 106. Third, check the date. Warrants have an expiration. If the warrant was issued 3 weeks ago and the limit is 10 days, it is stale. It is invalid. And finally, check the scope. What are they looking for? If the warrant authorizes a search for a stolen 60-inch television and they start looking inside your jewelry box or your gun safe, they are exceeding the scope of the warrant. A 60-inch TV cannot fit in a jewelry box. If you verify the warrant and it looks correct, you have to let them in. But even then, you do not consent. You say, "I am opening the door only because of this warrant. I do not consent to any search." Why do you say that? Because if it turns out later that the warrant was defective, maybe the judge didn't have probable cause, maybe the info was bad, your lawyer can try to get the evidence thrown out of court. But if you say, "Okay, come on in, look around," you have given consent. Consent cures a bad warrant. Never give consent. Let the warrant do the work. Now, we need to address the scary part, the exceptions. There are times when the police can smash your door down without a warrant and without your permission. These are called exigent circumstances. You need to know what these are so you can recognize the difference between a knock and talk and a raid. There are 3 main categories of exigent circumstances. Number 1, emergency aid. If the police have an objectively reasonable basis to believe that someone inside is seriously injured or threatened with imminent injury, they can enter. If they hear gunshots, screaming, or see a brawl through the window, they are coming in. The law values human life over the privacy of your home. Number 2. Hot pursuit. We touched on this with the Santana case. If the police are chasing a felony suspect down the street, and that suspect runs into your house, the police can follow him right in. They do not have to stop at the door and go find a judge while the suspect escapes out the back window. Number 3. Destruction of evidence. This is the tricky one. If the police reasonably believe that evidence is being destroyed right now, they can enter to stop it. There is a famous case called Kentucky versus King. Police were chasing a drug dealer. They lost him, but they smelled marijuana coming from an apartment door. They knocked loudly and announced police. Then, they heard noises inside that sounded like things being moved or destroyed. They kicked the door in. The Supreme Court ruled that this was legal. Even though the police created the urgency by knocking, the court said that because the occupants could have just stayed quiet or refused to answer, the fact that they started making destruction noises gave the police the right to enter. So what does this mean for you? It means that if you are doing something perfectly legal inside your home, but you start running around and flushing toilets when the police knock, you might be creating the very exigency they need to break your door down. Stay calm, stand still, speak clearly. Do not give them a reason to claim they heard evidence destruction. I want to return to the concept of the porch for a moment, because this is where many gun owners get confused. You might think, well, if they can walk up to my porch, can they bring a drug dog? Can they look through my windows with thermal cameras? The answer, generally, is no. The Supreme Court case Florida versus Jardines is a huge win for homeowners. In that case, police brought a drug-sniffing dog onto a man's front porch. The dog signaled that there were drugs inside. They used that to get a warrant. The Supreme Court threw it out. They said that while a normal visitor has an implied license to knock on your door, a normal visitor does not bring a drug-sniffing dog to investigate your house. By bringing the dog, the police exceeded their license. They turned the porch into a search zone. This means that the police are allowed to act like normal citizens on your porch. They can knock, they can wait, but they cannot use high-tech sense-enhancing tools to peer inside without a warrant. However, your own negligence can void this protection. If you leave your curtains wide open at night with the lights on, and an officer standing on the sidewalk can see you cleaning your guns or moving things around, that is plain view. You have no expectation of privacy for things you knowingly expose to the public. So, part of your door knock strategy happens long before the knock. It happens now. Close your blinds. Install a video doorbell so you don't have to open the main door to see who is there. Reinforce your door jambs. Make your home a hard target legally and physically. Let's bring this all back to a simple, actionable plan. Next time that pounding starts at 9 p.m., you are not going to panic. You are going to run the protocol. Step 1. Do not open the door. The threshold is lava. Step 2. Verify who it is. Who is it? Step 3. Establish the barrier. I am not coming out. Step 4. The shield. Do you have a warrant? If they don't, you say, I do not consent to any search. Please leave. And you walk away. If they do, you verify it. Signature, address, date, scope, and even then, you state clearly, I do not consent. This script is your legal armor. It protects you from the plain view doctrine. It protects you from the step outside trap. It protects you from consensual searches. The Fourth Amendment is a powerful shield, but it is heavy. You have to be the one to hold it up. The police will not hold it up for you. They are trained to get around it. You must be trained to maintain it. In the next video, we are going to talk about a scenario that is even more high pressure than the door knock. We are going to talk about what happens when you are compelled to leave your home. When you are in your vehicle and you see those blue lights in your rearview mirror. The rules of the road are very different from the rules of the house. I'll see you there. Stay safe, stay legal.